Can my ex ask the court to order me to pay child support? I have 50-50 custody currently, and we have currently no child support obligation for either parent. But the child's mother has alienated him against me, and now he refuses to visit me. The child is 16 years old. I cannot speak for all jurisdictions in response to this question, obviously, because I do not know the law in every jurisdiction, and I am not licensed to practice law in every jurisdiction. But I can tell you what I know and what I've experienced in the jurisdiction where I practice divorce and family law, Utah. Short answer, possibly, likely. Long, more explanatory answer, the scenario is as follows. The court has made a certain child custody and parent time award, but the child refuses to comply with the court-ordered child custody and parent time schedule and spends all of his or her time living with one parent and refuses to spend any time in the care and custody of the other parent, or at least very little time. So the questions are, can the fact that the child has, in essence, created a de facto sole custody arrangement, and if so, can the de facto sole custody arrangement result in the de facto non-custodial parent being forced to pay child support to the de facto custodial parent, even though that parent's de facto non-custodial status is in no way the other parent's fault? The answer is yes, it can. It's not inevitable, but it can and often does happen. 2, yes, it can. It's not inevitable, but can happen. Why? Before I address the question, let's discuss a bit of child support policy. Some would argue that the purpose of the child support payment obligation is to ensure that each parent has sufficient funds to provide for the child's financial needs and maintain a lifestyle commensurate with the parent's combined earnings. So if one parent has a lower income than the other parent, the policy goes that the court will order the more affluent parent to pay the other parent some money to help the less affluent parent maintain the lifestyle that the child ostensibly enjoys when in the care and custody of the more affluent parent. It's not the only way to craft child support policy, but it is a reasonable way. Courts that subscribe to this way of thinking then argue sometimes that if a child refuses to comply with, say, a joint physical custody award, resulting in only one parent being burdened with fully or primarily having to shelter, feed, clothe, educate, and entertain the child, it would thus be unfair to burden the now de facto, primary or sole custodial parent with all the financial burdens associated with the child's needs and allow the other parent to pay on a joint custody basis that's no longer being followed. The other parent, so the thinking goes, needs to pay his or her fair share of the child's financial support needs. When children spend time in the care and custody of both parents, then the financial support burdens are divided between both parents. Equal custody, equal division is the idea, at least when it comes to maintaining the lifestyle. That makes sense. That's patently fair. When the child spends all of his or her time in the care and custody of just one parent, then it would be unfair for that parent to be solely responsible for the child's financial support. If courts followed such a policy, then it is feared that as a means of avoiding the financial obligations of child support, parents would fight to ensure that only one parent has sole or primary custody of the child and thus be stuck with the sole financial obligations of support. So even when a court-ordered joint custodial parent has, through no fault of his or her own, been rendered a de facto non-custodial parent by the child refusing to comply with the court's custody order, many courts, many, not all, might react to this situation by 1, modifying the child custody order to reflect the de facto situation, and 2, consequently modifying the child support award. Some courts may take a different approach in such a situation, although such an approach is, in my experience, much less common. That approach would be based on the idea that children don't have the power to dictate child custody and parent time schedules to their parents and to the court. Therefore, if a child refuses to comply with the court's child custody and parent time orders, the court is not going to punish the innocent de facto non-custodial parent. But you can see why such an approach leaves a bad taste in the mouths of many people, not leastwise the de facto custodial parent. If the parent in the de facto custodial parent position can prove that he or she did not compel or induce the child to refuse to comply with the court's child custody and parent time orders, that parent could certainly argue that he or she is innocent too and should not be punished for the circumstances created by a non-compliant child. Which raises the next question and brings the discussion full circle. Why not have the court compel the child to comply with its child custody and parent time orders? I have addressed that question on Quora many times. That's Quora.com. And I've provided the links to those articles in the description section of this video.